And now, it's The Law Show on CL650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Good morning and welcome to The Law Show here on CL650. I'm Sterling Fox, joined in studio by John Lakes and John White, partners both at LakesWhyteLLP, involved in estate law and estate planning on the program. John Lakes and John White, welcome back, both of you. It's good to see you again.
Well, thank you. Good morning.
Thank you very much, Sterling.
We have a great program lined up today. We're going to get into some new millennium stuff, some cutting-edge science and technology stuff that deals with, of all things, estate law. And we're talking about, of course, all of these new forms of reproductive technologies and how that comes to affect the business and daily activities of estate lawyers like John Lakes and John White. But first, guys, tell us a little bit about the firm. Yours is a North Vancouver-based law firm, and you two fellas are both North Shore guys. John Lakes, you're the senior of this duo. Tell us a little bit about yourself and the beginnings of the firm.
Well, I grew up in North Van. I attended Highlands, Balmoral, and Delbrook. Went off to UBC. Spent a bit of time up north, but came back to the North Shore and been practicing in the North Shore since 1981. And I've had started the practice in 1986 and have been there ever since. We deal with North Van people, West Van people, Squamish people. I do a lot of wills and estates and small business and real estate, and I'm a solicitor, so I try to keep my clients out of court.
Well, that sounds like a full-time job, too, John.
And in most firms, you need a yin and a yang. So
right.
I'm yin, and John's the yang.
That meaning you would be the barrister, as in the fellow. When someone is compelled to go to court, you're the lawyer who shows up with that individual.
That's what I do.
But you're also a North Shore guy who just stepped aside for a few minutes and went to law school out of province, right?
I did. I decided to see the world a little bit, and so I went to Toronto for 3 years. Lived there, enjoyed it, went to school there, but I had no difficulty in coming straight back after school.
Just a little taste of how the other half lives, and then back home to where it's the sweetest, right?
It was enough of a taste.
Right. And so, John, you do, in addition, you do go to court as the barrister in this pair, but you do a lot of, in addition to estates and state litigation, you do other forms of law as well. What sort of other activities do you get involved in?
I do. I do a lot of commercial litigation. I do a number of personal injury cases. I do some real estate cases. I do what our community requires of lawyers, other than family law. We have a new lawyer with us who does that work. But I find that people in the North Shore need legal help in going to court with all sorts of cases.
Absolutely, yeah. Okay, so Lakes White is in North Vancouver, and you know, John Lakes, it's the law is that kind of career choice in which one would think, oh well, okay, I'm going to do this. I'm going to do estates law, and just kind of settle down into a comfortable, quiet little groove, and just sort of disappear. Well, of course, science and the law keep sort of intersecting with each other, and scientists keep you lawyers awake a lot, coming up with new and, well, different ways of doing things, and therefore causing the law to need to be changed. And when we talk in 2015 about inheritances as it might relate to reproductive technologies, we're in an area they hadn't even imagined when you were in law school, aren't we?
No, of course not, because when I was in law school, they didn't even have DNA at that point.
Right.
People used to determine inheritance through blood tests,
right,
things like that. But and you know, a baby was only born the one way.
That's right.
And even if there was artificial reproduction those days, it was really crude. It was through the turkey basters, basters, or else it was injected, but it was not. It was done within the body. So if a child was born through any intervention, was still born within 9 months.
Right. Now, John White, one of the new bits of law that you and your partner and all other estate lawyers in British Columbia have had to learn and deal with in recent times is WESA, the Wills, Estates, Succession Act. It's, about a year and a half old now, right, guys?
Yeah, just about.
About a year and a half. So that caused your business to change again with an upgrade, or a revision of the laws to reflect 2015 or new millennium realities. Does the new law in British Columbia address all of these reproductive issues that we're about to talk about here, John? Or is the law still desperately trying to catch up to science?
Well, I don't think that any law has ever managed to address all of the issues that come up with the area in which the law covers. WESA does have some language in it which is new, which talks about more modern reproductive technology. It makes provision, for example, of what happens if there is human reproductive material, either an embryo or sperm, which is stored somewhere when somebody dies.
Right, right.
And whereas it used to be that the only children considered as such under the old act were those who were actually living at the time the deceased passed away, or who were on the way, so to speak, and born within 9 months. Now there's provision for children to be conceived after the death of the deceased person,
right,
who can still inherit as children, even though they didn't exist at
they
all
went around when he
at
died.
the time of the death.
Right. So let's back it up a half step here. And John Lakes, help us with the legal definition. Let's get some legal definitions down here, because when in the context of inheritance and those who may challenge an inheritance, talk about who qualifies as family and why.
Well, about a child. To inherit as a child, you either have to be the biological child or else the legally adopted child. And that's quite a bit different from in family law, because if you're a stepchild in a family law context, then your step-parent may be responsible to pay maintenance for you and may have some rights to have custody. However, from an estate point of view, your step-parent owes nothing to you. There's no legal obligation to you whatsoever.
Now, this is the law show, and this is where it gets important for me to just stop and ask a silly question. Because one would think that the law would look at an individual the same way right across the board through all sorts of legal challenges and possibilities. But you're already saying that family law looks at a young person one way, and inheritance or estate law may look at that exact same person in a completely different legal way, right?
That's true. When they were doing, like WESA took 10
This is hard for people to understand, John.
Well, the WESA law, when it took them 10 or 12 years to come up with the legislation that was finally brought forward.
Okay.
And there was a decision by the powers to be not to include stepchildren as automatic beneficiaries, which I think they felt that there was a certain degree of certainty by doing it that way. Now, it doesn't mean that a person cannot look after their stepchild, so they could name their stepchild a beneficiary in the will, where they say, I have 3 children, Mary, George, and Henry, and Henry's my stepson, but for the purpose of this will, I treat him as my son.
Absolutely.
So you can do that.
Right.
You can adopt people as well, too, but I wasn't part of the panel that decided to not include stepchildren. But I presume that was meant that it would just create a lot of confusion. So how do you define a stepchild?
Well, I was going to ask both of you that. So what's the difference in law, in the definition, John, between a stepchild and an adopted child?
Well, one other point, though.
Okay.
Difference in family law, you remember that a child ceases to be a child under family law at 19.
Yes.
So a lot of people that end up being stepchildren may not even become a stepchild to their stepparent until they're in 30s or 40s, because let's say their fathers died and their mother's remarried, and they get very close to their stepfather, but even under family law there'd be no responsibility. So that was part of the decision. So right now a child is somebody who's either adopted or born to that biological parent, and just because they're on the birth certificate, I have to stop. Sorry, I've been talking since 6 a.m. Oh dear. This is why these shows aren't live, right?
Want one of these?
Yeah. Would you like more water too?
Excuse me.
Yeah, sure, not a problem. I wondered what you would do in this scenario. Okay. Okay, yeah, good. Well, no, I as I was popping my own, I wondered, what do you do on radio? I mean, in court you can get away with coughing. Once had Bill Rogers actually have his staff send me a packet of Fisherman's Friends because I was coughing too much in court. But what do you do on radio? I guess this is it.
So it's like the one sometimes when you do the live TV shows with Carol Barnett, they used to all end up having laughing half the time.
Oh yeah.
Remember that shit with Tim Conway?
Yeah.
Sorry, guys.
Yeah.
That's okay.
Okay. So
where do you want to go back to?
Where can you pick it up? Where can we pick it up?
Which was, can I hear the question? But you're already saying.
So it's, well, I remember.
I was going to ask both of you that. So what's the difference in law and the definition, John, between a stepchild and an adopted child?
Well, one other point though. The difference in family law, you remember that.
Okay, carry on.
The child ceased.
Well, no, can we get, is John's, you want to pick it up at the question then? Okay.
Yeah.
So, the question was, what's the difference in law between a stepchild and an adopted child? Okay.
All right.
Okay. My apologies, guys. That's
it happens.
Oh boy. Yeah.
Okay.
Yep.
Now, a child who is adopted, it's a legal procedure under the Adoption Act.
Right.
And so basically...
You're looking at one here, John. So I know what you're talking about.
Yeah, so there has to be a court procedure. There has to be various reports done by social services agencies.
Right.
And so there is a court order that...
Are we rolling, Dwayne? Oh, for crying out loud.
Okay.
Well, I had no idea. I'm so sorry. I was waiting for a cue. So do we have the question is already on tape? So I'm sorry, John. Please pick it up.
Okay. And a child that is adopted is adopted under the Adoption Act, and it requires a court order by the courts wherein they deem the current parents to be the legal parents. And then in the process, your birth registration is changed, so it will show your father and your adopted father and your mother as your legal parent. So in a case where you have a woman who's the natural parent and she's married, then the husband will bring forward the court order to apply to be the adopted father, and then the birth registration will change to show the adopted father as the new legal parent.
Right.
And it also means that the biological parent no longer has any rights nor responsibilities as well. So if somebody is adopted and then they find out that their biological father was a multimillionaire, well, they're out of luck.
Right. There's no legal recourse to go because that door closed when the new one opened and you were given your new identity.
Well, currently there isn't. You never know whether there will be some charter challenge in the future. But but under the current law, if you've been adopted, then it's like your legal parents have been replaced by new parents.
And John White, it sounds like a stepchild, given the sort of formal definition of the transfer of name and identity that an adopted child goes through, a stepchild, it sounds like similar but less formal. Is that the legal way of looking at it?
That is very much the legal way of looking at it, and that really captures the distinction between a stepchild and an adoptive child for the purpose of inheritance. There's a limited definition of child for inheritance in situations where the will maker dies without a will, or the will maker makes a will, but the beneficiaries want to vary or change that will.
Right.
spouses get to vary or change a will, of course, but only natural children or adoptive children get to have the standing to bring an application to vary a will. Stepchildren don't.
Now, you're the court guy. We have a fairly well-known British Columbia name. You brought some paperwork with you based on a trial case that had been brought before the courts here in British Columbia involving a rather famous BC name and a person who was a stepchild who applied for greater status in order to inherit, right?
Well, that's precisely the case. The case is Perry and McCutcheon. Neither name is particularly well known. The name that's well known in this case is the late Herb Doman.
The lumber magnate.
The lumber magnate.
Right. Very well known British Columbia name, too.
Indeed. Indeed.
So tell us the story.
Well, Ms. Perry, the plaintiff, was listed in her birth certificate as the daughter of Herb Doman and his wife Harjinder. And for at least some of her life, she probably believed that she was the natural daughter of Herb and Harjinder.
Okay.
The problem was that she wasn't. And as the case goes on, you can see layers of the onion being peeled back to show exactly what happened in this case.
So what was the story? What was the backstory?
Well, the backstory is that at the time Herb Doman married his wife Harjinder, she was already expecting the plaintiff, Ms. Perry,
okay.
But Herb was not the father.
Okay.
According to Harjinder's evidence, Herb knew that at the time they got married, but he allowed himself to be put on the birth certificate anyway, I guess for public consumption.
Sure.
But Herb was not the father. As the court case proceeded, there was a DNA test done. This goes back to 2007, 2008.
And why did this woman apply to the courts in the first place? Was she left out of the will?
She was left out of the will.
Uh-huh.
And she was...
See, it's usually follow the money, isn't it, John?
It's always follow the money.
Okay, all right.
And in this case, she was left out of the will, and she was applying under what we then called the Wills Variation Act. It's now a part of WESA.
Okay.
But it's basically the same for this purpose, which is she wanted the ability to vary Herb's will so that she could be given some of the estate under that will.
She wanted to vary or change it in her favor.
Absolutely.
Okay, so a DNA test is called for,
right.
Looking for more evidence to support her case as being Herb's child.
And just the reason that they needed that evidence was that in order for her even to be able to bring the application to vary the will, she has to be either the natural child or the adopted child of Herb. Everybody knew she wasn't the adopted child.
Right, sure.
So either she's the natural child of Herb or she's out of luck.
Okay.
And so the DNA test was commissioned to show whether or not she was the natural child of Herb.
Okay, so the whole case is now hinging on the results of the DNA test, which are
there was a 0% chance that Herb was her natural father.
Okay. So then what happens?
Well, she made some other arguments, but the bottom line is she could not bring herself within that group of individuals who could apply under the Wills Variation Act, now WESA,
right,
to vary the will.
And we don't know, do we, whether she was left any money by Herb in the first place, do we?
Well, we have a little insight into that because, as I say, another one of those layers of the onion got peeled back, and it turns out that about 25 years or so before Herb passed away, there was a meeting between Herb, or at least his lawyer, and this plaintiff, Ms. Perry, down in Puyallup, where Herb agrees to give her, and does give her, $25,000, and in return she signs a contract which says, among other things, she will not challenge or seek to vary Herb's will when he dies, and acknowledges that Herb is not her father.
So she signs this document, cashes the check, and years later decides, oh, what the heck, nobody will remember that. Let's go at it anyway.
I think she decided that she was being pressured and didn't really understand legally what she was doing, which unfortunately is is an allegation made in many cases. It was made in this one.
Oh, so, I mean, really, at some point, some lawyer for the other side's got to be able to stand up with this document she signed for which she was paid $25,000 and go, look, do you not remember signing this? Yeah. At which point, John, I'm thinking the case may have pretty much been over.
I would think that she had some serious problems at that point and had to come up with a pretty good explanation. She clearly didn't come up with a sufficient explanation.
So interesting. So John Lakes, this woman was not. She was a stepchild. She was neither the legal, biological child nor the legally adopted child. So she has this non-status in inheritance law of a stepchild.
Well, she wasn't even the stepchild because she was never raised by Herb Doman either.
I see.
But I think the important thing about this case is that he is shown on her birth registration as being her father.
Right.
And prima facie, that is evidence that he is the father.
And for a person growing up, if you look at your birth certificate and there's the guy's name, well, that's my dad.
But that's where it's not always the case. So, for example, if you have a child that is conceived by artificial insemination, and let's say the mother is the donor of the eggs, but there's somebody else who's the donor of the sperm, but when you register the birth, it shows the wife and her current husband as the parents. For family law, he's the parent. However, for estate law, for him to be the parent, he would have to legally adopt this child because he's not the biological child. And that's where you get into this problem with just because you're shown on the birth registration as the parent doesn't necessarily mean you are.
And, excuse me, and you thought inheritance and estate law was kind of a snoozy thing, didn't you? Here with a big surprise on this edition of The Law Show, friends. We're out here on the cutting edge, not only of science, but of the law, with John Lakes and John White from LakesWhyteLLP in North Vancouver, and we're just getting started. Back after this.
There's more of the show still ahead. This is The Law Show on CL 650.